morning. I'm Lieutenant Colonel Joan Summers. I'm the chair of the Military Science Department, and I am a 2003 graduate of Western Illinois University. I'm currently serving in my 17th year as an active duty military intelligence officer. Today, we celebrate Constitution Day at Western Illinois University. Some 26 years ago, Ms. Louise Lee, a nearly 90-year-old woman from Los Angeles, California, enrolled in a course on U.S. constitutional history, sponsored by the National Center for Constitutional Studies. Inspired by what she learned, Ms. Lee founded a nonprofit organization called Constitution Day Incorporated. The goal of the organization was to set aside one day a year to learn about and honor the nation's founding document. Ms. Lee lobbied Congress vigorously and convinced Robert Byrd, an influential U.S. Senator from West Virginia, to include an 11th hour Constitution Day amendment to the Omnibus Spending Bill. The bill subsequently became law and took effect in 2005. Under the law, every educational institution receiving federal funding must celebrate the U.S. Constitution each year, or on or near September 17th. This date was chosen because September 17th, 1787 was when the delegates to the U.S. Constitution approved the document and sent it to the states for ratification. While all educational institutions across the nation must observe Constitution Day, it is up to each institution to decide how to celebrate it. Since 2006, the Department of History and Political Science and the Centennial Honors College have taken the lead in planning and organizing Constitution Day at Western Illinois University. Under the direction of Dr. Rick Hardy, Dr. Keith Boeckelman, and Dr. Paul Schlag, Western Illinois University has annually organized panel discussions on the Constitution and encouraged students to display research posters on constitutional concepts, leading Supreme Court decisions, or Supreme Court justices. Indeed, we may be the only university in the nation that features research posters by undergraduate students. Unfortunately, due to the COVID-19 pandemic, we are unable to host an in-person poster conference today. Each year, we select a significant topic dealing with the U.S. Constitution. Several of the topics discussed over the years include freedom of speech, Fourth Amendment rights, gender equality, civil rights, freedom of religion, privacy rights, the right to due process, property rights, freedom of press, federalism, immigration and citizenship, and separation of powers and checks and balances. This year's theme is Article 5 of the Constitution. This is a very important provision of the U.S. Constitution, which unfortunately is often overlooked and seriously underappreciated by many U.S. citizens. Again, I'm Lieutenant Colonel Joan Summers, and I am pleased to serve as moderator for this year's panel as we commemorate Constitution Day at Western Illinois University. I want to thank the Centennial Honors College, the Department of History and Political Science, and University Television at Western Illinois University for producing and recording this event. Today's expert panelists are Dr. Keith Boeckelman, Chair of the Department of History and Political Science, and Dr. Rick Hardy, former Dean of the Centennial Honors College and now Professor of Political Science. Dr. Boeckelman is a professor and chair of the Department of Political Science and also serves as the interim chair for the Department of History. He earned his PhD in political science from the University of Illinois in 1990 and served on the faculties of the University of North Carolina at Pembroke, Louisiana State University, and Texas A&M University before joining the Western Illinois University Department of Political Science in 1998. From the outset, he has been widely recognized by his students and colleagues alike as one of the best professors at Western Illinois University. In 2007, he was recognized as the most outstanding professor, and in 2018, he was named the John Hawas Lecturer. As a noted author and scholar, his distinguished academic career has focused on public administration, state and local government, public policy, experiential learning, and civic engagement. Dr. Boeckelman, thank you for joining us today.
Thank you.
Dr. Hardy is a nationally renowned professor in the Political Science Department. From 2011 to 2020, he served as the director and then dean of the Centennial Honors College. He graduated with honors from Western Illinois University's Political Science Department and earned an MA at the University of North Dakota and a PhD from the University of Iowa. As one of the top lecturers and researchers of the nation, he has nearly 50 years of college teaching experience, serving on the faculties of Northern State University, the University of Missouri-Columbia, Duke University, and Western Illinois University. His areas of expertise include U.S. constitutional law, civil rights, civil liberties, public policy, and American politics. His impressive academic dossier includes nearly 50 legitimate publications, including books, anthologies, peer-reviewed articles, and book chapters. Gentlemen, thank you both for being here to participate in today's discussion.
Thank you. You're welcome.
My first question for discussion is, what is Article 5 of the U.S. Constitution, and why is it important to study?
Well, thank you, Lieutenant Colonel Summers, for hosting this, and I appreciate it. Article 5 is called the Amending article of the Constitution. For those who are unfamiliar, the Constitution has a preamble and 7 articles, and then 27 amendments. The Article 5 is called the Amending article because it provides ways that we can change the Constitution. Why is it important? It is important because when the framers met in Philadelphia in 1787, they were there for, quote, the sole and express purpose of revising the Articles of Confederation, end quote. What we were existing under was an Articles of Confederation. It was a loose conglomeration of states, and all 13 states were sovereign. They could coin their own money, they could regulate weights and measures, they could negotiate treaties with the Native Americans and with international powers. But it was a mess. The major problem was that it could not be amended, even though the document was called the Articles of Confederation and Perpetual Union. It belies the problems that it had. There was no way it could last. Essentially, it would take a unanimous vote to do anything, and if there was a conflict between 2 states, there's no way you're going to get unanimity. So it had to be amended. It could not function. It couldn't function any longer. So the framers were pragmatic individuals. They knew that things would have to change in time, and so they put into this Article 5. It's based upon the federal principle. That is, since both the national government and the states derive their authority through the Constitution, that is, we, the people of the United States, in order to form this more perfect union, that both of them would have to take a part in amending the Constitution. Dr. Boeckelman would probably tell us more about the process by which that could be amended.
Well, sure, I can say a little bit about that. So essentially it's a 2-step process. Any amendment has to be both proposed and then it has to be ratified. So to propose an amendment, it takes a 2/3 vote of both houses of Congress or a national convention called by 2/3 of the states. The first method is the only one that's been used. There's a lot of fear of what might happen if there were a new constitutional convention, as Dr. Hardy alluded to. There was kind of a bait and switch aspect to the Constitutional Convention. It was originally seen as just revising the articles, and then pretty quickly they flushed the whole thing, so to speak. Then the second step is to ratify, and that can be done in one of 2 ways. Also, either through a 3/4 vote of the state legislatures or by special ratifying convention in 3/4 of the state. That second method has only been used once for the repeal of prohibition. There was a lot of consternation that they wouldn't be able to get the repeal of prohibition through the state legislatures, and that 3/4, more than 1/4 of the states would not go along with that. Just to kind of piggyback also on what Dr. Hardy said, the Articles of Confederation was in many ways an unbalanced document, that it's not really structured in a way, as he said, that could last. And I also often tell my students the Article 5 is trying to balance the present and the future. It makes it hard to amend the Constitution, so it's certainly not an easy process. It only happened 27 times, but it is possible. And so unlike under the Articles of Federation, where it's practically impossible.
Why do you think that the founders thought that both Congress and the states had to participate in amending the Constitution?
Well, this is another aspect of the balance that's inherent in the Constitution, I think, that they were trying to balance the powers of the national government and the states, and so they wanted both them to be involved, both the states themselves and the national government to be able to sign off on a constitutional amendment. They didn't want either party to either level of government to be left out, and so that's inherent in the federal system. That's very important in the Constitution itself.
What amendments are in the Bill of Rights, and how did they come about?
Well, when the Constitution was ratified, before it was ratified, as soon as the ink was dried, opposition sprung up throughout the states. And a number of prominent people under pseudonyms such as Brutus and Cato and other famous people in history, they started publishing what we call the Anti-Federalist Papers, criticizing our Constitution and why it should not be approved. They objected to judiciary, which they thought was going to be too powerful. They objected to, for example, Article 6, Section 2 of the Constitution, which is called the Supremacy Clause, which could, they felt, render the states ineffective. So there was a lot of opposition. So there was publications by the other side. They're called the Federalist Papers, mainly by Alexander Hamilton and James Madison and to some extent John Jay. And they argued in favor of the Constitution. And so the biggest objection, however, was that it contained no Bill of Rights. And one of the prime movers of the convention who actually walked out was George Mason of Virginia. He said, "I will not sign this document." He said, "I would rather cut off my right arm than to sign the document as it presently exists because it has no containment of Bill of Rights." Hamilton would argue, well, there's a Bill of Rights. You've got Article 1, Section 9 and Article 1, Section 10, no ex post facto law, no bill of attainder. We play plenty of restrictions on the government. But it wasn't enough. So it looked like the Constitution was going to fail completely until agreement was made. And agreement was made at the urging of George Washington to James Madison to make a deal with George Mason and the rest of the Anti-Federalists. And so a deal was struck. And so on the very first day of Congress, the Constitution was approved. And on the very first day, George Mason and James Madison announced that they were going to add a Bill of Rights. And that may be the first and only time in recorded history where Congress ever kept a promise. I'm exaggerating a little bit, but maybe not too much. And so they entertained amendments. And there were 125 or so proposals to amend the new Constitution before it even started, right? And so George Mason, who was an attorney, and James Madison, the philosopher, worked together to craft this document. There were actually 17 that they came up with. 12 of them passed Congress, and 10 of them were sent out to 10 of them were ratified by the states. There were actually 12 that were approved by Congress, and the first 2 were not approved ratified by the states, and that becomes the Bill of Rights. And I think it's important to note that the very first words of the First Amendment, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech." The very first word is Congress shall. So these were restrictions on the national government. And over the years, some of our founders' fears were misplaced because oftentimes it was the state governments taking away our freedoms. So that's why we have a Bill of Rights. So collectively, they're known as the first 10 amendments, although there are some Supreme Court justices that say the first 8 amendments plus the 14th Amendment are the Bill of Rights because of the way it's expanded. However, whatever nomenclature you use, today we normally think of the first 10 amendments, and they were ratified in 1791, and we've been in effect since that time.
If I could just add one little kind of interesting addendum to that. The most recent amendment, the 27th Amendment, which prohibits congressional pay raises, was originally proposed as part of the Bill of Rights, and it kind of sat around for a couple centuries. And then there was a student in an American government class at the University of Texas who wrote a term paper saying that this amendment was still alive and it could still be ratified even though it had been sitting around for so long. And his teacher gave him a bad grade on it, so he was so angered by this that he almost single-handedly went out and got the state legislatures to complete this ratification process, and this did then become 200 years later part of the Bill of, or not part of the Bill of Rights, but part of the Constitution as the 27th Amendment.
That's right. The young man's name was Gregory Watson, and as I recall, Dr. Boeckelman, he was assigned to do something on the Equal Rights Amendment, and he disobeyed the order, so to speak, And he wrote something. He found something fascinating, that there were no time limits on the First Amendment. And so, even though we've added 37 states since the original 13 states, incidentally, Dr. Boeckelman, the very first, as you probably know, the very first constitutional amendment proposed, but did not get ratified, was one that called for one member of Congress for every 30,000 inhabitants. Now today, that would mean that in the United States Congress, we'd have over 10,000 members of the House of Representatives. It would be like herding squirrels, wouldn't it? All right, so I'm glad that amendment did not get passed. And then the original Second Amendment was that no member of Congress can take a pay raise until after an election has interceded. And that's the one that Gregory Watson came up with. So isn't it amazing to our listeners, viewers out here, especially if you're a college student, think of what a college student could do. This was a college student who found something, was unwilling to give in on something, and he stood on his principles, and it ended up being the 27th Amendment of the Constitution. It was the original Madison Amendment.
And just to kind of piggyback off on the original First Amendment never ratified,
yeah.
That, as you say, would have made Congress pretty unwieldy given that size, but I think it is probably clear that the current level of representation that each member of Congress is representing, 600, 700,000, is probably not what the founders envisioned. I think they thought that would make people, the members of Congress, the members of the House, I should say, too out of touch with their
the population of the United States it's an estimate. Until our first census, and I don't think that was very accurate, was about 3.6 million. So it's the city of Chicago is almost three times bigger than the population of the United States, and our largest city was Philadelphia, which was about the present day size of Quincy, Illinois. So you can see that they probably could never have envisioned what we would have today. So we can understand why they wanted to put that in there. Yeah.
Dr. Boeckelman, have there ever been any issues over the proposal and ratification of the Constitution?
The Constitution itself or the amendments?
I would say the Constitution.
Well, certainly the Constitution was controversial at the time. They, in fact, had to set up special procedures. Some of those that are kind of reflected in the amendment process itself. But it's pretty clear that if they would have gone through the normal process to ratify the Constitution under the Art of Confederation, it would have never been ratified. Rhode Island, for example, was so opposed to the Constitution that state didn't even show up to the convention. And under the Art of Confederation, all 13 states had to agree for it to go into effect. And so there's no way that would have happened. So they did some kind of special procedures to get around that process. They said once the 13 states agreed to the Constitution would go into effect. Again, this was technically against the Art of Confederation, which required all 13 states to agree, which, as Dr. Hardy said, would be almost impossible. Also, they set up special ratifying conventions in the states to ratify the Constitution, which again was at odds with the Art of Confederation, which said that the state legislatures had to agree, but the state legislatures were the ones that were going to lose the most power if the Constitution would have gone into effect, and so they were unlikely to go along with that. So really they jerry-rigged these procedures to try to get the Constitution through, and it was controversial. As much as we revere the Constitution now, we sometimes forget how controversial it was at the time. And Dr. Hardy mentioned the Federalist Papers, and so there was a full-bore PR campaign to try to convince people that the Constitution was desirable. And so certainly it was certainly a controversial aspect at the time.
And I might piggyback on that. There have been some research that suggests that probably less than 5% of the people actually had a voice in adopting the Constitution, because of voter restrictions. Suffrage was very limited to white males. Oftentimes you had to have property, you had to be 21 years of age. It was, by today's standards, it doesn't have the same input that the populace would have today.
And certainly they were not voting on this directly.
No, they were not. Concerning the amendments, I could talk about some of the controversy over the amendments. We've had a number of controversies over the amendments. For example, the 13th, 14th, and 15th amendments are so-called Civil War amendments. The 13th Amendment proscribes slavery and indentured servitude. That was passed in 1865. 1868, the 14th Amendment. 1870, the 15th Amendment prohibiting discrimination against black males for voting. The 14th Amendment we'll get into a little bit here. But those amendments were passed, and if it takes 3/4 of the states to ratify a constitutional amendment, and how would you possibly get that adopted when half of the states are southern states? Well, the answer is because the southern states were under martial law. They were selected, put into military districts, and Southern Confederate sympathizers and participants could not vote. And so you had legislatures controlled by carpetbaggers and newly enfranchised African Americans. And the condition was you couldn't get representation in Congress until you ratified those amendments. So even that's controversial today. And so there have been other ones, if I might mention. The first controversy occurred back in 1798. It was a case called Hollingsworth versus Virginia. And it had to do with the 11th Amendment. Just to give you a little background, the original provision of the Constitution states that under Article 3, a state could be sued in original jurisdiction in the U.S. Supreme Court by a citizen of another state or a foreign country. Why they put that in the Constitution, I have no idea. Because immediately there was a lawsuit. One of the most important lawsuits, first lawsuit, major lawsuit, was called Chisholm versus Georgia in 1793. It's a case where a man wants to sue the state of Georgia for money that they didn't pay. They reneged on a contract. So he takes it directly to the Supreme Court, and the state of Georgia doesn't show up. In American jurisprudence, you lose when you don't show up. You're compelled to show up or you lose. Anyway, John Jay ruled for Chisholm, in this case, the person suing the state. And this got the state of Georgia so upset, and other states, they said, we can't be sued. It will ruin our sovereignty. So they pushed for the 11th Amendment. The 11th Amendment was added in 1798. The problem is, and the 11th Amendment says no state shall be sued in the federal courts without its consent, by a citizen of another state or a foreign citizen in the Supreme Court without its consent. Well, the problem was the 11th Amendment, the concern was somebody says, I'm challenging that because President Washington didn't sign the amendment. It was ratified by 2/3 vote of both houses, but the president didn't sign it. And he said that would give him the chance to veto a proposed constitutional amendment. So it goes before the Supreme Court, and Justice Oliver Ellsworth, who was the third Chief Justice, said, there's nothing in Article 5 that says the president signs this. It can be done by a joint resolution of Congress, and that's how it's done. It's nothing to prevent the president from signing the amendment, but he has no voice in it. This is among Congress, not the presidency. And I might add, it would be superfluous anyway, because it would, in order to overturn a veto, it would require 2/3 vote. They already have the 2/3 vote there. So that was a very controversial one. And I have others. Do you have any others you want to talk about?
Just controversial. Well, I was going to ask you, actually.
Yeah.
I'm not really familiar with the jurisprudence on this,
Yeah.
but with respect to the 14th Amendment and so
Sure.
forth, and the Reconstruction Amendments more generally,
Right.
has there been cases related to that in terms of their legitimacy? And I guess I'm particularly thinking of it in terms of there's this question now about birthright citizenship in the 14th Amendment and
Yeah.
the question of whether that should be overturned.
Oh, that's a good
and I wonder if there's been any cases or jurisprudence related to that.
Well, we've had three constitutional amendments that reverse a U.S. Supreme Court decision. The 11th Amendment I just alluded to was to overcome Chisholm versus Georgia. What Dr. Boeckelman is talking about is that the 14th Amendment was intended to overturn the case of Dred Scott versus Sanford in 1857. Dred Scott was a man of color who was brought to slavery by his owner from Virginia into Illinois, a free state. And then he passed away, the owner passed away, and he was sold to an Army surgeon who then moved around. He went to Rock Island, then he went to Fort Snelling in Wisconsin, back to Rock Island, and through the help of some abolitionists, Dred Scott brought a lawsuit contending that he was a free person by virtue of the fact that he went to a free territory. So Missouri, where he had lived, was a slave state. So that brought up the question of who is protected. So the very first words of the 14th Amendment state very clearly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the states and the United States and the states wherein they reside. Now, it makes it very clear that the purpose of the 14th Amendment is to say that slaves, if you're born here, you're an American citizen. And then you're protected, and it says no state shall deny anyone due process or equal protection law or privileges or immunities. Now, that should have been the case right there. All persons. We've had problems ever since that time of what is citizenship. We had the question of, is Barack Obama, was he born in the United States? Or is Kamala Harris an American citizen because her parents were foreign born? Well, it doesn't matter. As long as they're born inside the United States or a territory or a military base, they are U.S. citizens and are protected through all the rights and privileges that any other American has. So that's been a controversial one over the years, but the Supreme Court made it clear, the case dealing with a person of Chinese nationality born in the United States, and he went to visit his parents in China. He came back, they said, you're not a citizen. He went to the Supreme Court. The Supreme Court says, no, read the wording of the Constitution. So it is still controversial today, and I don't know why. Maybe we haven't done a good job in our civics classes to teach them that that's what it means. Yeah.
You know, just to add one thing about the constitutional amendments overruling Supreme Court decisions, there's some consideration, this is really in the early stages right now, of a possible constitutional amendment to overturn the Citizens United decision of 2010, which essentially prohibited a lot of limits on campaign contributions. And so some people argue that this has opened up too much money into politics and so forth. And so there had been various amendments introduced in Congress, and that's about as far as it's gone to propose an amendment to overturn Citizens United. But that's kind of an ongoing process historically, that sometimes if there's a Supreme Court decision that's controversial, the amendment process can be used to address that.
Well, point in fact, I think I've lost track, Dr. Boeckelman, but I think we're up to about 11,000, pushing 12,000 proposed constitutional amendments. And most of those have been since 1976. And so it becomes very political to say, I'm going to run for Congress and I'm going to propose that we change this. I'm going to propose we change and we want to get back at the Supreme Court. The Supreme Court has become very much of a lightning rod and very highly political. It always has been. I mean, it's both a judicial court and a political court. And where one begins, I guess if you like the decision, you call it justice. If you don't, you call it politics. And so there have been a lot of those amendments proposed. The ones that have been the most intriguing, however, I think, are those that call for a U.S. Constitutional Convention that petition. There have been about 300 attempts to bring about 300 attempts at least to call for a constitutional convention. Now, the last constitutional convention we had was in 1787. We haven't had one since then, but as Dr. Boeckelman pointed out at the very outset of our conversation, that the Article 5 gives you that option. You could have a constitutional convention when petitioned by 2/3 of the states. We've come very close on a couple of occasions. One was an Equal Rights Amendment that was in the 1970s, and it ended in 82 with time limit. And the other one that came very close was a decision called Reynolds versus Sims. It was a case in 1960, was it 64, I guess, to overturn, to make both houses of the state legislatures based on population rather than area. and led by a man from Illinois by the name of Everett Dirksen, a U.S. Senator. We fell one state short of calling for a constitutional convention, a U.S. constitutional convention. Now, I might ask Dr. Boeckelman, if I may follow up, what would happen if we did call for it?
For a constitutional convention?
Yeah, how would the delegates be selected?
I don't know. Do you know?
No, I don't know either. Who would preside over that?
Yeah, good question. I mean, I guess.
How many votes would each state be entitled to have at a constitutional convention?
I assume one if you look at the president.
Well, you're right. The very first constitutional convention, every state had one vote, irrespective of its population. Could you imagine California with 36 million people saying to Alaska with, 500,000 people that you should have the same amount of votes that we have won? That would be. And then what would prevent a runaway convention?
But I guess all these things, at the first constitutional convention, of course, they set their own rules. So who knows, really?
Well, that's right. And but the first constitutional convention was in absolute secrecy. It was in the middle of summer. It was a hot summer in Philadelphia, and they kept the windows down, and there were no reporters around. Right? Could you imagine trying to keep the reporters out? You imagine trying to keep leaks? There's an old saying that 3 may keep a secret if 2 of them are dead. Right? Well, there's no way you could keep that secret.
Well, there's no Freedom of Information Act then, so we've
well,
got. So
that's right.
Good luck keeping the reporters out of something like this.
FOIAs, okay. But then again, what would prevent a runaway convention? I don't know. I don't even know if this would work. Would the First Amendment pass today?
Yeah, good question. I mean, I have my doubts.
Would the Second Amendment? Probably not.
Yeah. I mean, any of them.
Well, yeah. And
maybe the third. That one's pretty uncontroversial.
No quartering of soldiers, right?
But maybe.
I'm sorry.
Lieutenant Colonel Summers may want to weigh in on that one. But
the soldiers used to be quartered during the colonial
yeah, she
period.
probably doesn't want to quarter soldiers.
There was someplace I would not want to quarter. But that would be a real problem if we had a constitutional convention, because we don't know. George Washington, presided over our first constitutional convention. He didn't say much. There were only 39 people who signed the original document. Only 55 of the 74 delegates ever attended. It was just. I don't see how we could make it today with today's television and social media. We better pray, in my opinion, that we don't have it. I think it's better to keep the document we have and adjust it as we see fit, even though it's very difficult to do that.
Well, and even finding somebody revered enough like George Washington to preside over this would, I think, be impossible in practical terms now. I mean, I think there's no one.
So you didn't think
maybe
Barack Obama or maybe George Herbert Walker, G.W. Bush, maybe.
Yeah, I don't think either of those would be.
How about somebody from Fox News or CNN?
Yeah, good luck with that.
No, I don't think it would be very difficult, wouldn't it?
Yeah, I think it'd be.
I just think it would be very difficult to find anybody to preside over.
Just one other thing too. I think we've gotten pretty close to a balanced budget amendment, having a constitutional convention on that. I think we're 2 or 3 states short.
Yeah.
Now calling for a constitutional amendment to have a balanced budget amendment as well.
Incidentally, on that, and that's there. I don't think there was a time limit on that one.
I don't believe so. So that was
Congress had put some time limits on. Up until the 18th Amendment, there's no time limits. Congress put it in the 18th Amendment. That's prohibition, and they called for a 7-year time limit. And so in the 23rd Amendment, which was to give D.C. The right to vote for presidential elections, they put it in the resolution, not the amendment. And so with the Equal Rights Amendment, they had it in the resolution. And the time limit expired, 7 years expired in 1979. And then Congress expanded it to 1982, and it died just short. 2 states that didn't do it were Illinois and Missouri. And I happened to be in the state of Missouri when the Equal Rights Amendment was being debated. And we were being boycotted. Were you being boycotted here in the state?
Yeah, in fact, the Midwest Political Science Association was boycotted
it went
a couple
someplace
times
that made Cincinnati,
yeah.
I think, that year, and it instead of Chicago, where it was normally held. So it was hurting economically. But I went to the state hearings in Jefferson City, Missouri, and I sat through the hearings on the and debate over the Equal Rights Amendment. Those who supported the Equal Rights Amendment called everybody in that room a sexist and Neanderthals, but it was all sexist. If you don't support women's rights, you're a sexist. The other side came back and said, we cannot tolerate women as prisoners of war. Women will be drafted, women will be put as prisoners of war, and also they feared that you would eventually be interpreted so you'd have same-sex prisons, same-sex toilets. The arguments that went on there, and it did not pass Missouri, and the state of Missouri got boycotted. So there's controversy over that. By the way, Keith, a couple little tidbits. When the 14th Amendment was initially adopted, it was passed by Ohio and New Jersey, and they subsequently rescinded their approval. And Congress says, no, once you approve it, you're in.
Yeah, so there's similar controversies, with the Equal Rights Amendment that several states after they had originally ratified it, 5 states had pulled back on
no,
that.
they're not going to do it. Yeah. So what do you do? It seems to have an asymmetrical effect, but Congress, they've said it's usually, the Supreme Court has looked at this and said, we'll leave it up to Congress. It's a political question. We'll leave them to determine whether or not they're going to count it or not. That's been the issue. We had another issue that took place, and I'm trying to think of what, I have to cheat just a little bit. Hawk versus Smith in 1920. It had to do with the 18th Amendment, which called for prohibition. And the state of Ohio, the legislature voted to approve it, and then they took so much flack from their constituents. They thought they were all going to be ousted at the polls. So quickly in that same session, they put it before the voters in the form of a referendum, which they could under their state constitution. The state referendum, where the voters got to decide, voted to kill prohibition, right? So a proponent of this, Mr. Hawk, sues the Secretary of State saying it can't go into effect because it wasn't approved by the legislature. It goes before the Supreme Court, and in a 9-0 opinion by Justice Rufus Day, the justice said, the Supreme Court ruled, it cannot be done by a referendum. It has to be done by the legislature. Now, isn't it amazing that it has that the people who actually had a voice in it don't have a voice, right? If I may, there's one more that's controversial. It's Dr. Boeckelman mentioned the 21st Amendment, which repealed the 18th. It's the only amendment which repeals it. And at that time, prohibition wasn't working very well. Prohibition was put into effect by the Volstead Act. And the Volstead Act made it illegal to manufacture, sell, or transport alcoholic beverages. But it wasn't necessarily illegal to buy it or drink it, right? And there were so many ways around it, and it just wasn't being enforced. So in 1933, the Democrats won Congress, and most of them said, let's get rid of this thing. And so it got through the legislature, 2/3 vote, and it went out, it was going to go to the states. The states were controlled by rural elements. This is before reapportionment took place. And they were pro-dry. And there was no way you're going to get the 30, it'd have to be 37 states at that time to ratify the constitutional amendment. So what they did is they chose the second option, the only time, that it goes to state ratifying conventions. Now, this is what I find unique about it, about the 21st Amendment. It's the only time that the people actually had a voice in the Constitution. Because in that state, they decided to have state conventions, and in each state, they went to at-large elections. And every candidate to run to the convention pledged to vote either pro-wet or pro-dry. So essentially, when the people went to polls, they selected the person. It was nothing more than a referendum on the Constitution. And as I said, it's the only unique way that's been done. And I maintain, and I could be the only person in the world who believes this, but I think you could go towards resolving the abortion issue by using the 21st Amendment. And in fact, I proposed something and went to Congress, and it was discussed by Daniel Patrick Moynihan and very seriously by John Danforth of Missouri. And that's this. You take the pro-life people and the pro-choice people in Congress, let them write their amendment any way they want to. I don't care how they want to write it. Let them write it. And then you put them into the same amendment, A and B. 1A is pro-choice, 1A is pro-life, or flip it around, I don't care. And then you add a second section. Section that this amendment must be ratified by state conventions, and the delegates to the convention must choose between 1A and 1B. Now, all of a sudden, you got them talking, and you have to consider who would win. One side's out here, the other side's out here, and they won't give in. And by the way, it's either pro-life or pro-choice, and anybody tries to run down the middle becomes political roadkill. Most of us are in the middle, but we become political roadkill. So you lose both sides and they'll work against you. So what happens is you have to pick a side. It's a zero-sum game almost always. Well, this thing, they have to anticipate what the people are going to think. And it might forge them to come towards the middle a little bit. And so it would be a unique consultation with the people. It would be the only time the people actually have a voice in the Constitution. And that's the 21st Amendment. And I think there's a way we could do it. But you'd have to have Congress members willing to do it. And I don't see anybody willing to do that.
We've talked about a lot of intriguing amendments. Dr. Boeckelman, do you have a favorite amendment?
Well, I think it's hard to think about how America would be different if we didn't have a Bill of Rights, so obviously that's important. But I think my favorite amendments are those that have expanded voting rights and have expanded democracy in various ways. So examples would be the 19th Amendment, which we just celebrated the 100th anniversary of, which gave women the right to vote. The 15th Amendment, of course, which you've alluded to, gave African-American men the right to vote, former slaves the right to vote. The 24th Amendment gave 18-year-olds the right to vote. So these amendments, I think I would say, are my favorites.
Do you have a favorite amendment?
I think some of my favorites have to do with the presidency. We have the 12th Amendment, resulting in the election of 1800, in which there was a tie between Adams and between Burr and Jefferson. They were of the same political parties. The first year we had political parties. They didn't exist when the Constitution was written. So everybody ran as a partisan, and there was actually, everyone knew that Jefferson was intended to be the president and Burr was supposed to be the vice president. But every elector got 2 votes under the Constitution, and they also went party votes, so there was a tie. And it went 26 ballots when it went in the House of Representatives before Alexander Hamilton helped push it over to his rival, Thomas Jefferson. And they realized it would be a problem with that, so they had to change it so that when you vote for a president, the electors get 2 votes, 2 votes, one for president, one for vice president. And I also, you also have the 20th Amendment, lame duck amendment, which shortens the term between the lame duck when you're ousted and when you take office. We also have the 22nd Amendment, which limits the president to 2 terms or 10 years. Republicans gained control of Congress, and they said, no more Roosevelts, no more somebody running for 4 terms, running for getting elected 4 times. And finally, the 25th Amendment, and thank God we have that, because that calls for disability and selecting a vice president in case there was a vacancy. We've been without a vice president 8 times in American history. So when the assassination of John Kennedy occurred, it made it clear, that we needed to do something. And so it's taken place, and we used it with Richard Nixon when he resigned. We've used it to change vice presidents too. So those are very important elements of the Constitution. Something that was needed.
Is Article 5 the only way in which the Constitution can be amended?
Well, it can be amended actually in many ways. One is custom and usage. For example, executive orders by the president. They have the effective law as long as if they carry out a policy of Congress or they carry out a Supreme Court decision or a treaty. Senatorial courtesy, refusing to select a nominee from your party if you're not consulted, if you're of that party. A lot of custom and usage, executive agreements that have the same status as a treaty, even though they're not in the Constitution. And of course, Supreme Court has changed it a great deal because the Constitution is perfectly parsimonious. That is, it's left as a document that allows it to breathe with the times. And so Supreme Court, what is probable cause? What is cruel and unusual punishment? All these things have been changed with the times depending on who the justices were.
I think also there's sometimes confusion about what's constitutional and what's not. I mean, people think, I guess the filibuster, things like that come to mind. People assume that these are in the Constitution or some procedures, but they're really not. So these things can be changed relatively easily, but psychologically, sometimes people think, oh, since this has been around a long time, it must be part of the Constitution or something like that.
You don't want to tinker with the Constitution, and it's an important symbolic thing. One last thing that I want to mention, Lieutenant Colonel, is the Fifth Amendment also contains a provision. The Fifth Article contains something we call the entrenchment clause. And it says, no state shall lose equal representation in the Senate unless it approves. Now, why they would put that in there is beyond me, but it was a deal cut in the Constitution. And it said it's the only provision in the Constitution that cannot be amended. It's called the entrenched clause. Why? Because no state would give up its equal representation. I mean, Illinois, we're going to give up one of our votes and give it to Alaska. It's just not going to happen. So that's why it's called the entrenched clause of the Constitution, and it's often overlooked, and it's not particularly important, but apparently it was to the people who wrote it.
Well, as you say, it's unrealistic, even if that weren't in there, to expect the Senate to be amended. Enough states to go along with amending the Senate. But I did see some speculation that you could have like a two-stage amendment. First, you'd amend the Constitution to get rid of that clause, and then the second part of it, then you have a separate amendment which would rejigger the Senate somehow. I mean, I guess the argument is that some people don't like the way the Senate's constructed because Wyoming gets the same number of senators as California, and many people consider that unfair. So. But again, practically, there's no way that would happen. That there would be certainly more than one-fourth of the states say, no way are we going to give up that.
I do think that Article 5 is often ignored by people. I think this is a very important thing. It's critical for the functioning of our Constitution. There's a lot of historical importance to it, and it kind of makes the federal system work. It's difficult to change. I mean, since 1791, we've only had 17 amendments, right, from the original Bill of Rights. But it's there to protect us. It's there to ensure the federal principle, I think.
Well, and substantively, a lot of the issues society deals with, whether it's balanced budget amendment or ERA, some of these things we've talked about, or the Electoral College, there's been some discussion of fixing that or changing that. These issues are run through Article 5, and so, it is obviously very important, as Dr. Hardy suggests, even though we haven't gotten around to talk to it until 2020, but I think it's important that we've done so.
Okay. All right, good.
Well, Dr. Hardy and Dr. Boeckelman, thank you so much for sharing your expertise and knowledge of the United States Constitution with us as we celebrate Constitution Day. Today's discussion has been informative and enlightening. And thank you for joining us today as we continue to explore the nation's founding document, the U.S. Constitution.